Hello, and welcome to the Vlogging Pod. As of October 2025, the Department of Justice became the center of a heated debate after being linked to what many saw as a backdoor attempt at registering gun owners. Through a court case known as Reese versus ATF, the DOJ stood behind a judgment that, at least for the short time, required major gun rights organizations to hand over verified membership lists. Critics warned that such a move would effectively expose lawful gun owners and infringe on their constitutional right to associate freely with government oversight. The case itself stemmed from a challenge to federal law that restricts licensed handgun dealers from selling to adults under 21. Several groups, including the Second Amendment Foundation and the Firearms Policy Coalition, joined the lawsuit. When the court issued its ruling, it included language that those organizations shall provide to defendant a verified list of their names as of November 6, 2020. That single line set off alarms across the country. It wasn't a law to disarm citizens. It was, to many, a legal pathway that could open the door to a government record of who owns guns. Almost immediately, the backlash was fierce. Gun rights advocates argued that forcing membership disclosure would violate the First Amendment, the right to free association, by making people fearful of joining the advocacy groups that defend the Second Amendment. They emphasized that privacy and association is a cornerstone of American liberty. Even the Department of Justice soon appeared to recognize the constitutional tension. In a rare turn, the DOJ turned the plaintiffs in filing a joint motion asking the court to amend its own judgment, changing shall provide to may provide, and affirming that the government does not, as general policy, compel disclosure of the identity of members of private organizations. That amendment mattered. It signaled that the DOJ was stepping back from what could have been interpreted as a broad attempt to catalog lawful gun owners. Finally, the court vacated that, officially erased it, the order that had required the list to be turned over. By vacating that section, the judge effectively wiped it off the record, ensuring that no list of members could be submitted and no precedent for forced disclosure would stand. Legally speaking, this is a First Amendment victory. The court recognized that even in cases involving firearms, where public safety and constitutional rights are colliding, the government cannot compel private organizations to expose their supporters. The case did not end the fight over the right to bear arms, but it reminded the public that constitutional protections overlap. The First Amendment shield of privacy can protect the Second Amendment defenders. For everyday citizens, this moment was more than just courtroom language. It was a glimpse of how quickly a technical phrase in a judgment can test the boundaries between governmental authority and personal liberty. And while this particular attempt was stopped, it's a reminder that vigilance over constitutional rights must remain constant, no matter which administration holds power. Today's sources come from Judgment in 1820 Handgun Purchase Ban Severely Limits Relief, Second Amendment Foundation, SAF.org. DOJ moves to amend court judgment requesting membership list in Reese versus ATF, News 2A. Order demanding protection of SAF memberships list vacated, Second Amendment Foundation, SAF.org. Thank you for listening. Until next time, bye-bye for now.